seems to allow me to project my voice better. So, good morning. We will call to order the September 20th, 2021 meeting of the Board of Elections, and we'll rise and say the national anthem. Pardon me, the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right, so the first order of business is going to be to administer the oath to Mr. McBlain. And I have it here. Raise your right hand, John. I, John McBlain, do solemnly swear that I will support, obey, and defend the Constitution of the United States
the Constitution of the United States
and the Constitution of this Commonwealth.
and the Constitution of this Commonwealth.
And I will discharge the duties of my office as a member of the Board of Elections with fidelity.
That I will discharge the duties of my office as a member of the Board of Elections with fidelity.
Congratulations, John. And we are very privileged to welcome Mr. McBlain here today. As most of you undoubtedly know, he has a long history of service to this county as a elected public official in both his township and on the county basis. He was also, for some periods of time, the solicitor of the Board of Elections. So welcome back. And we will proceed. So we have the agenda. It was publicized. It has been distributed today. Are there any additions or comments on the agenda from my fellow board members? All right. We will move for the approval of the minutes of the September 21st, 2020 meeting that were distributed before today. I'll second, because I don't know that it's proper for Mr. McBlain to participate since he wasn't there. So I'll second. All those in favor say aye.
Aye.
No, I'll abstain from that vote as I was not present for that meeting.
Very good. So the minutes are approved, and we will now turn to Mr. Allen's report.
Good morning, board members, and welcome aboard, Mr. McBlain. First off, I just wanted to discuss a ballot preparation status. As of noon yesterday, representatives of the IT department were wrapping up the ballot designs for all 428 of the precinct ballot styles. Just as a little background, the Department of State only certified the complete ballot last week, but obviously we did a little bit of advance work based on who won in the primaries and what offices and how they needed to be presented. And we presented a mock-up of the ballots as long ago as August 29 to party leaders in a joint call with the Democratic and Republican party leaders to explain how we were going to do this, because there are a couple of unique issues with this election. This is the first election, a municipal election, on paper ballots and with cross-filing. So that means the candidates who used to be listed in two separate columns because they won the Democratic and the Republican primary are now going to be listed once to prevent overvotes. That's per state law. That's consistent statewide. And also unique this election is the fact that because we're on paper ballots, the state constitution requires us to have the judicial retention questions on a separate paper ballot. So this is going to be our first two-ballot or two-page or two-sheet, however you want to put it, ballot. So there's some interesting wrinkles in making sure that the design works from there. We can't just slap the retention questions on the back of what's now the A ballot. So there's going to be an A ballot and a B ballot issued to each and every voter. So from here, it's going to go, the whole process of the ballot preparation is going to go to the proofing stage in the Bureau of Elections with the goal of locking down all the files sometime this week. I'm cautiously optimistic that V-drives could begin arriving at our voting machine warehouse later this week for the start of logic and accuracy testing. And that's all I have to report at this time on that, if there are any questions.
Anyone else have any questions?
I do have a question, Mr. Chairman. Mr. Allen, thank you for that report. My thought always had, when I served previously, was that especially when big changes are made, such as from the machines to the paper ballots, is to keep as much consistency as possible so that there's the least amount of change that would confuse people. My understanding is the draft of the ballots now has candidates sort of stacked top and bottom rather than side to side. And I apologize because obviously I haven't been at the last meetings, so I don't know. Was that change approved by the Board of Elections?
That's a change that's required under the Hart intercivic voting equipment that we have. So there is no ability to arrange a ballot doing side by side by parties and create one long dual column, for example, or a triple column if there were an independent or green party. So the way the voting equipment works is it reads a ballot with the candidates stacked up, and then it looks for, if it's a vote for one office, only one mark that fills in the box to the left of one of the candidates, or if it's a vote for two or vote for not more than 3 or 4, 3, and then it also detects for an undervote or an overvote and alerts the voter accordingly. So yeah, this is nothing like the Danaher equipment. This is how the new voting equipment pretty much statewide now operates, so that we have to stack the candidates in each office so that an office is presented, and then the candidates are listed in the order of party of the governor. So when the Republican Party wins the governor's office, then the Republicans would be listed first, and then Republican, Democrat. Currently, the Democratic governor is in office, so it goes Dem and/or Dem Rep, followed by Rep.
Right. So this stacking is a function that's required by Hart.
Well,
No, it's the new
law.
The new law that requires us to go to paper ballots. So it's not just Hart. You're going to find this in the ES&S system. You're going to find this in the Dominion system. You're going to find this in any voting system that uses paper ballots.
Yeah, I don't mean to interrupt, and Mr. Parks isn't here, so it's kind of unfair for Mr. Molinari, who's pinching to have to deal with this. But my understanding is that the statute requiring paper balloting changes the methodology by which candidates have to be listed on the ballot, and they have to be listed sequentially for each office. So as Mr. Allen was explaining, for school board where you have cross filings, what used to be, the party that held the governor's office was column A, the second party was column B. So it doesn't work that way now. Everybody's in one column. The party that holds the governor's office candidates are first. Cross-filed winners are second, if you win on both sides, and then the remaining candidates are listed third, but all sequentially in the column. The statute requires that. And
Right, so it's not the Hart intercivic.
well, he
No,
was
it's
saying the
state law.
machine requires it,
It's
but the
state law.
machine works that way because that's what the law requires.
Right.
State law now requires each candidate to be listed once
Okay.
on a paper ballot. So it can be either Dem first, and then Dem Rep, or Rep, and then Rep, or it can be Dem Rep if they were the top vote getter in the Democratic primary, followed by a Dem, followed by a Rep. So, or 2 reps, if there was, or it can be Dem, Rep, in a vote for 2 situation. So this is a statewide change per the law in the transition to the paper ballots. And if you think about it, if we were to list, let's say Sally Jones won both the Republican primary and got enough votes for the Democratic primary. If we were to list on paper ballots Sally Jones in 2 columns now, it would lead undoubtedly to overvotes. And I don't know the thinking of the legislature, but I think after paper ballots started being used in certain jurisdictions, they may have run into this. And so you would have, under the Danaher system, once you vote for Sally Jones, it would block you from voting for her again. But on a paper ballot, there's nothing there to block you from that, so you would have a lot of frustrated voters having their ballots rejected and whatnot, because they'd be marking both.
Okay.
So that's the genesis of the change.
I appreciate that. And can I prevail upon Mr. Molinaro or his colleagues, if you could send me a copy of that provision of the act so I can get myself up to speed, I'd much appreciate it.
Yeah, Mr. Parks can do it easily because he has circulated that before. That's how I knew that. Wasn't I looked that up on my own?
Okay.
Okay.
Thank you very much.
Sure.
Next up, the ballot printing and mailing is still projected to occur toward the end of September, with a 1-week turnaround from the printer and fulfillment house on the first batch of what we have right now, currently about 34,500 vote by mail and approximately 500 absentee ballots. At this time, we anticipate those files would go to the printers at the end of September to allow for a mail drop on or about October 1, 2, 3, 4. Meantime, the 20 military overseas ballots went out on time last week. There's a 45-day federal law, UOCAVA, and also it dovetails with the state law. And we met that requirement last week with basically write-in ballots, as I understand it. I'm getting nods from my staff. Any questions about that, I'd be more than happy to answer.
I do have one. I guess this is a function of somebody becoming aware that I had been appointed last week. You start getting calls over the weekend, asking you questions. But I did get an inquiry regarding the permanent mail-in list, and I presume that's the universe, the 34,500, Mr. Allen, that you just referenced, were being mailed out. I guess as this campaign's going on, they identified, or they had a question about, they saw there were at least 2 people they were aware of on the permanent list that had recently passed away. And I don't know what the answer to this is. Is there a fail-safe, or is there some kind of check procedure to cross-check to see those on the permanent list, whether or not they've died since the last election?
Excellent question. I'm pleased to be able to have an answer for you. Last week, I was speaking with our voter registration manager, Crystal Winterbottom, about doing something in addition to what the Department of State performs in terms of working with what's called ERIC. ERIC is the Electronic Registration and Information Center. And ERIC looks for duplicates in other jurisdictions, whether they're in the Commonwealth or beyond, and tries to help the jurisdictions determine which is the more recent in a duplicate case. It also looks for deaths. But there is always a lag between what we may have at the county level through the Register of Wills or whatnot, and what the Department of State has through cross-referencing with records from the Pennsylvania Department of Public Health. And therefore, I was going to present this at the next meeting, but I'm glad you brought it up. We're looking to work with the Register of Wills, whatnot, to get an updated list of everything and all of the records of death from the previous 6 months. Because under the law, whether it's federal law or state law, a death record, it doesn't require, there isn't the 90-day requirement for canvassing. It's final. And it's a way of canceling the voter registration. Once we cancel the voter registration, even if we've mailed out that ballot, if it were to come back in that situation, let's say we cancel it in the middle of October, and let's say we mailed it out October 3rd, once we've canceled it, once it hits our system at the wharf, it will be detected that that's a canceled registration, and it will be set aside as a ballot that cannot and will not be processed unless or until there's a recount or a challenge, or someone says, hey, it wasn't me who died, that was somebody else named Bob Smith.
Yeah. I think it would benefit us, especially in this day and age, Mr. Chairman, where rightly or wrongly the security of elections, comes into question, to have a process in place where we can assure the residents that whether we catch it before or after, to have something in place where, I just saw a news article where a man was convicted last week of voting for his son, voting in place of his son in addition to himself. So we just want to protect against having family members or somebody else voting how they perhaps think their dead relative may have wanted to vote, but making sure that that doesn't occur.
No,
So I
I
thank
very
Mr.
much-
Allen for that response.
No, I very much agree, Mr. McBlain, and I am glad that Mr. Allen is looking into this, and hopefully we have this in place for the cycle, and or if not, at least as soon as possible, so. All right, Mr. Allen, back to your agenda.
Status of purchasing of the, both the pre-election mailing and the voting booths. Both the pre-election household mailing bid and the voting booth are scheduled to be received and open later this month for consideration by the County Council and the Board of Elections in early October. And we've provided to the board prior to this meeting individually the preliminary designs of the household pre-election mailing. And if you have any questions on this matter, I'd be more than happy to take those.
Mr. Chair, I just wanted to thank you, Mr. Allen. I believe that's the mailing in which you were able to indicate that there's going to be a two-page ballot at this election, and I appreciate you adding that to that. I think it'll be helpful, or I hope it will be helpful, so thank you.
John, did you see this, or did this come out before you were appointed? You know what we're talking about?
I'm vaguely familiar, but I have not seen it.
Yeah, it's a postcard, here it is, with a graphic on it that,
That's a front and back of a postcard. It's an 8.5 by 5.5, which still allows us to get postcard rates. But we would want to do this with first-class postage, pre-sorted. The reason being, if you do standard pre-sort, it could wait 9 days to be delivered or something like that. It could wait till whenever, you know, the local post office gets around to it. I don't think it would take 9 days, but because the Postal Service has been really good about giving high priority to election mail, but nonetheless, essentially we're doing this mailing for, because county council and the county administration were concerned that we don't know what's going to happen with the Delta variant. We don't know if it might cause polling places to suddenly withdraw or whatever, depending on, you know, the situation. So we wanted to make sure that those people who are voters who are going to vote in person are reminded to check their polling place to make sure it hasn't changed in the final week in case they don't tune into every Board of Elections meeting. And secondly, if they want to apply to vote by mail, they may do so.
Mr. McBlain, the part I was talking about was we had recommend that Mr. Allen, if he could, include that graphic at the bottom or something like that. I think it's a good graphic about the 2 pages. But if you have any, you know, one of the big concerns is undervotes with the 2-page, either with mail-in voting or in person. So as we go along, that's a concern to me, to make sure we educate voters on how to make sure that they don't undervote if they don't intend to.
Graphic looks great. Now, this would be, I missed it, mailed out to all voters?
Yes.
Okay.
It'd be all voters except those who have already applied to vote by mail. So we would exclude those from the list to try to save some postage, because if they've already applied, the presumption is, you know, there's already a ballot in the pipeline for them.
and it's all voter households or whatever, so it's not each.
So if we
you
have
would
a
get
Smith
4
and a
of them in your house
Smith,
or whatever.
and they have identical addresses, we'll just make that the Smith household. If we have a Smith and a Jones, even if they might be married or cousins or whatever, living in the same household, we would mail out an individual piece to Smith and Jones, because we don't know, you know, that could be an address failing.
I think that's a great idea, let people know. Raises, I guess, it would be an interesting exercise. What happens when the postcards come back? It's undeliverable.
When the postcards come back undeliverable, we're within the 90-day window prior to the election. So under federal law, under the Help America Vote Act, we're not allowed to move that person from active to inactive. However, the day after Election Day, we are allowed to act on adjusting that registration to move it from active to inactive. And we are not going to be mailing to inactive voters, by the way.
Right, okay. Can we, when they come in and if they're returned for some reason, can we compile a list of voters that are doing that?
We would, and if you notice on the top of the postcard toward the top, we don't make this a forwardable piece. We make it return service requested so that the post office has the obligation to return it to us, usually with a yellow label at the bottom of the postcard that indicates the forwarding order expired, or this is where they now reside, or what have you. We can't, under the federal law, adjust the registration this close to an election because it could be a temporary situation. They relocated for a while to work on it at a different job. They're helping a sick relative, whatever the case may be. But so that's the philosophy behind the federal law.
Okay.
But yes, after the election, we can use it for May
Great.
of 2022.
Okay. And when does this go out?
Cross our fingers, make sure that we get bids, and that there's a paper supply. Right now, there are envelope and paper shortages nationwide. So, you know, if everything falls into place, this hopefully will go out on or about October 5th, between the 5th and the 10th.
Okay, thank you.
And we took the approval action at a prior meeting, and the council has approved it, so. All right, anything else on this, Ashley?
No, thank you.
All right, so I think we're up to voter service centers.
There's not a whole lot new to report there. We're still working with the City of Chester and Upper Darby as far as wrapping up agreements to address items like security, staffing on Saturdays, and cleaning services. This would be the opening of voter service centers, similar to what we did in November 2020 at 2 stations, one in Chester at the southern part of the county and Upper Darby out east. So we're waiting on ironing out the agreements on those.
And what were the two, in Upper Darby and Chester, where are the locations?
Upper Darby's location last year was problematic. It was on the 4th floor. It created several different issues. This is prior to my being here, but I've heard plenty about it.
4th floor of the county building down there? In
No,
69th
it was
Street?
a Human Services building.
Yeah.
And so I don't know if that's a county facility or not, but it was nonetheless problematic for voters. In any event, so we approached Upper Darby Township, where they have the ground floor access, which is accessible. The room is unfinished, but it's finished enough that we could use this before they start doing the rehab of that. I think it's a former library area that's currently not been a library for a number of years, but it's right next to the Public Works building, right there, right next to our Dropbox. So. At that same site.
And where's the Chester?
Chester City Hall. So we're looking to possibly get in a community room, whereas we used to be right behind security. The concern there is if there's a line of voters, that just exposes staff that much more to the Delta variant. So if we can go through a different doorway, we can use a community center room. So we met with the mayor and a staff member there. They were very gracious and very, very helpful.
No questions for me.
Thank you.
Meantime, and other updates, Delaware County's election staff is among a select few who are serving on a committee to advise the state on using, for lack of a better word, plain language in emails and letters that let voters know about items such as voter registration deadlines and/or the opportunity to apply online to vote by mail, or next year, if the law still is in place for the, I dislike using the word permanent, but we're trying to get them, or they're also amenable to using the word annual, which is a little more accurate, the annual vote by mail filings, so that people might apply next year for the May and November 2022 elections. We're also working to simplify that for ourselves if that law is in place for use next January. And then this past Friday, I was invited to give a presentation on election security with the League of Women Voters for Delaware County, or Central Delaware County. We covered a wide range of issues. They had a lot of questions, especially about, and we've received emails on this as well, about whether or not there could be subpoenas for voters' private or personal identifying information. So that definitely came up as well.
Very good. Any other matters before we get to the complaint?
Nope.
No. Anybody questions for Mr. Allen?
No, thank you.
Okay, all right, let's get to the fun part here. This is complicated, but I guess you'll present the issue, Mr. Allen, and Mr. Molinari, you'll give us your analysis, and then we'll have some discussion.
Well, one of the things I love about elections is that each cycle seems to bring a new, unique situation that maybe case law has, settled somewhere else in the state years ago on an unrelated office. And this past week, we received a complaint from a voter in Wallingford, Swarthmore School District, Region 1, because a candidate who's on the unofficial candidate is listed for 2 Region 1 school board seats that are on the ballots this fall. So as background, Amy Caruso, among other candidates, won their respective party primaries on May 18 to appear on the November 2 ballots in a contest for the 4-year seat on Region 1, which was scheduled to come up this year, just because it was time. It was, it was the previous term was ending this year. Then this summer, there was an August 2021 resignation by another Region 1 board member who was in the middle of his or her 4-year term, and that created a temporary vacancy that they could fill for now by appointment, but it also created a vacancy for essentially a 2-year midterm. So that created a contest on the ballot for a 2-year seat for Region 1. And the Republican Party nominated Amy Caruso to also appear on the ballot as a candidate for the 2-year seat in Region 1. So we forwarded the complaint to the board as soon as we received it, and also to legal counsel. And we advised the political parties that we'd be bringing up this complaint today. And I'm asking the board to hear and consider the laws and the legal analyses to direct staff on how to proceed with this nomination for the 2-year seat.
Okay, and before Mr. Molinari presents, is there anybody here on behalf of Ms. Caruso or either of the political parties? Councilwoman Ruther, you're here for the Democratic Party, I assume?
Yeah, I'm the person with me is the person who submitted the complaint.
Okay, very good. So just so you're clear, we're going to listen to Mr. Molinari's opinion. We'll have a motion. We'll have discussion of the board. We'll have public comment and give you opportunity to present your position with respect to this, and then we'll consider whether or not we take action, okay? All right.
Chair, I believe the woman in the corner, did you also raise your hand, miss? She also raised her hand. I was having fun.
And you are? Welcome, Mrs. Caruso. So you understand what we're going to do. Very good. Okay. Mr. Molinari.
Okay. Thank you. Hello, everyone. I'm filling in. My name is Michael Molinaro. I'm from the solicitor's office. I'm filling in for Manley Parks, who is typically the solicitor to this board. Over this weekend, Manley, myself, and Nick Centrella from his office have done extensive research on both the case law. Granted, we couldn't find any on point, as well as the statutory provisions. The easiest way for me to present this to the board is I'll give you Manley's decision first, and then I'll kind of explain how he got to that decision. So Manley states that sections 993 and 994, somewhat inexplicably, do not include the same office limitations found in section 979. Although there is a prohibition in section 993 against the nomination of a candidate under that section who has been nominated by, quote, any political party or any other political body, end quote, for, quote, any office to be filled at the ensuing November election, end quote. The plain language of the code clearly carves out elected school directors, which is the office in question here, from that prohibition. Although the statutory scheme does not seem to make much sense, as best as I can determine, the nomination here is permitted, even though it would not have been if it were to fill a vacancy created with a death or withdrawal of a candidate, which is the section of 997. So basically, the only case kind of had a little help was from 1903. So it's not really an issue that's come before the courts at all. And I will say that Manley is correct. Section 993 of the code is the applicable code. And the code does, as Manley stated, this is a person who resigned midterm. So there's 2 years left on a term. It's our understanding that there is a vacancy committee on that school board, and the school board has filled the vacancy through the end of this year. So now we have what's called an election, special election, or just election. So this can be on the ballot to fill the resignee's 2-year remaining term. Coincidentally, there is a 4-year term for the same office. Different terms, same office. So, and Ms. Caruso has now presented nomination certificates for the one and a petition for the second one to be on the ballot. One, A, to fill the unexpired term, and 2, to fill the expired term, which is so anyhow. Section 993 provides in part that nominations to fill such vacancies shall be made by political parties in accordance with the party rules relating to filling the vacancies by means of nomination certificates in the form prescribed. So we believe a nomination certificate has been filed on behalf of Ms. Caruso concerning the unexpired 2-year term. This is where the confusion comes in. It says, no such nomination certificate shall nominate any person who has already been nominated by any other political party or by any political body for the same office unless such person is a candidate for the office of, and school director is one of the carved out exceptions. Now, why is the school director carved out of this section? It's also carved out as a municipal court judge as well as a common pleas judge. The interpretation could be, and again, there's no case law to say yay or nay, the interpretation could be those positions that are carved out can be cross-filed. So was the intent of the statute to say, if I have already been nominated petition as a Republican, can I now have a nomination certificate as a Democrat? Because you're allowed to cross-file in those positions. Could not find any case law on point to say yay or nay. So it's really a speculation as to what was the intent of that carve-out. So for sake of that not being interpreted anywhere, Mr. Manley has suggested that that running for both positions is acceptable under the current statute and common law. I would also say that there may be some issues with ballot clarity and confusion. The same person running twice on the same ballot. Also, if there, just so everybody knows, if there's any objectors or anybody's filing an objection to whatever the board decides, we have set forth 4 dates that will be going before a judge, and that'll be October 1st, October 8th, October 14th, and October 26th, that we already have our appointments reviews are scheduled, so those dates are available. If somebody should disagree with what's going to happen today. I think I have to, I myself will defer to Mr. Manley, as, yeah, this is his niche of the law. And Mr. Manley says that it seems to be okay.
All right,
The only
so-
other issue that I would say is that, granted, if Ms. Caruso was to win both positions, you'd be back to the same position you were today, which is you're going to have a vacancy, because she's only going to take one oath, I would think.
All right, so to summarize, and, notwithstanding, if Ms. Caruso is to prevail for both positions, that's a mandamus action that'll be in the Court of Common Pleas, and not a matter for us to consider. But based on what's in front of us today, whether or not Ms. Caruso's nomination for the two-year term in the special election is the recommendation of the Solicitor's Office that we deny the complaint, correct?
Yes.
Thank you.
That'd be perfect.
All right, so that was, like many things in the Pennsylvania Election Code, in 100 years of revision and amendment, it's not always a clear path to get from point A to point B, but in the situation we have before us, where you have a candidate on the ballot for a school board office, and then there's a nomination certificate for a vacant school board office, it appears that the code would permit that to happen, and based on that review of the code, it's the solicitor's recommendation that we deny the complaint that's been presented. Does anybody want to make a motion so that we can begin discussion of the issue?
Also move, Mr. Chairman.
I'll second the motion.
So a motion's been moved and seconded. We'll have, maybe we'll have some discussion amongst ourselves, and then we'll give the complainant an opportunity for public comment, and anyone else, including Ms. Caruso, to respond. Is there a comment, discussion? Or do we want to hear from the
I'd
complainant?
actually, I don't know. I mean, I'd almost want to hear from, if Ms. Caruso wanted to speak to this in particular.
And if I could, just as maybe a preliminary matter on it, I heard the explanation from the solicitor. I think I agree with it based on the carve-out, but also because I would note that the statute talks about the same office. And here, it's a similar office, it's for the same place, but it actually is a different office. I don't know how effective politically it is to run the same person, for both of those spots, or what confusion it might cause, but the so-called anti-poach statute, really looks to prevent, taking somebody that had lost perhaps in the primary from the other party and putting them on your ballot to sort of take advantage of that. But I want to just back up a second, and I don't know the answer to this, and we don't have to resolve it today, but I perhaps ask the solicitor, is that I'm not quite sure why the Board of Elections is entertaining this now. And everything that we do is statutory based. There's got to be a provision in the statutes that allows us to take an action or not. And just my familiarity with election law over the years is this seems to be a complaint or an objection that would typically be brought to the court to resolve about whether somebody is eligible and meets the criteria for that. I think, generally speaking, my awareness of the election code states that when a candidate comes in and files a nomination petition, we look at it to make sure that on the face of it, it is correct, but that we don't look behind the information that's there. That's something that would go to the courts. And I only say this because I guess in my former life as the tip of the spear, I had a case, where I argued, I apologize, the same thing, that the election board ought to take a look at, whether or not somebody was eligible to be there. And the Court of Common Pleas ultimately agreed with me, but ultimately the Pennsylvania Supreme Court disagreed with me and said the election board didn't have the authority to sort of make that determination for a school board seat similarly to this. It wasn't the same objection, but it was the same concept. So again, it's something that perhaps based upon the recommendation, we don't need to resolve today, but also I certainly wouldn't want to see the election board become sort of the second bite of the apple, that if you didn't go to court within the prescribed time period originally, you can't come back to the Board of Election sort of after the fact on an objection to make that decision. So I don't know. I don't know whether.
No, I think it's a fair question, and I raised it last week with the solicitor. Why is this in front of us? Why isn't this at the Court of Common Pleas? If we take the papers over the counter, haven't we actually accepted them? And his thought was that it's not nomination petition, right? It is a party's, I'm going to say nomination, but I know it's not the right word in the code, for a special election. And that, we have to make a determination, obviously, on the face of the papers, and that because we know this candidate is on the ballot already, does that come within the scope of that? So it was his thought that it would be appropriate for us to consider it, and also given the fact that we have some time before the election, and whoever thinks we're wrong can ask the court to figure that out.
Great.
So that's why I said, we have a meeting next week, let's put it on the agenda. If we're wrong, somebody tell us we're wrong.
Yep.
And I do anticipate the way it's going to work out. It may be a mood issue here, but we did think about that last week. So, and a very valid point, because as people know, we don't decide whether your signatures are valid, for instance. That's an objection to be taken with Court of Common Pleas. But this is here today, and we'll consider it, and whoever disagrees can ask the court.
Thank you, Mr. Chairman.
Whether
Mr. Chairman, if I may.
Just for the record, I just want to emphasize that I agree with Board Member McBlain on this, and this struck us as a four corners type of situation. So we wouldn't dig into, was the committee that met properly formed? Did they really have a quorum? So forth and so on, the details. We just are accepting it in on the four corners. Then the question became, okay, which law, applies here? And I just want to clarify, Mr. Molinaro did a great job of listing all the laws. There was a question about Section 979, and 979 is really about vacancies in nomination, where someone, for example, runs and wins in the primary and then decides they don't want to or cannot run in the general. And 993 and 994 address this situation where there's a vacancy in office. So, it's minutia, and yet we felt the need to bring it before the board because it struck us as the four corners aspect. So I agree with you.
Mr. Chairman, if I could one step further, and speaking with Manley also, the consideration was the board possibly had a duty under Section 976 which deals with examination, nomination petitions, certificates, and papers that they have to reject or accept if it contains material errors or defects apparent on the face thereof, and that's under 976 Section A. So I think that's how I made it to your agenda.
Right, it was whether there was a defect on the face, because, as Mr. Allen said, it wasn't like we had to go beyond the face of the paper to determine there was potentially an issue here. So that's why we're here. We've had you wait a long time.
We would
but-
ask that anybody who address, please come to the microphone.
My name is Christine Ruther. I am the chair of the Nether Providence Democratic Committee. And I will tell you, in some respects, I'm sort of agnostic about this for the reasons that Mr. McBlain noted. Politically, how smart is it for somebody to be on the ballot? You can claim that a two-year seat is on the same region of the same school board is a different office. But the fact is, a person cannot occupy the two-year seat and the four-year seat at the same time. And that's my concern. I mean, somebody is going to be out there running. The way that the new ballots are set up, the old idea that somebody who won a cross-filed primary on both sides, which one of the candidates for the four-year seat in Region 1 did do, doesn't really get the benefit. They're theoretically unopposed, but what you've got are three candidates running for two seats, and he's just one of the three candidates. It doesn't matter that he's got both an R and a D next to his name. So I think it is very possible, that the candidate who survived the Republican Party could theoretically win. And we've got a situation where that same person who's been campaigning for a year for that seat is now running for a two-year seat against a person who was just nominated. My concern is, and this is just what I want to bring to your attention and have you focus on. I mean, there's two. Number one, to answer the question of why didn't we go to court, I didn't know who was nominated until the Thursday after that person had been nominated. Unlike a situation with the normal nominations that happened by the parties for the primaries, everybody knows you've got to go check and find out if somebody was nominated, and then you have to go to court, and there's court dates set up and everything else. I was going to have to go file a petition without any of that, not knowing who it was, not even knowing what the deadlines were, because there's not a statutory deadline, as far as I know, other than reverting back to what it would have been for. And by the way, theoretically, if that deadline was 1 week from the date the nominations closed, I can go to court today before 4:30 and file a petition if I want to, because it's 7 days from the date the nominations filed. And that nomination deadline was the 13th, if I'm correct. Am I correct in that?
Yes, I believe it was the 13th. I believe it was the 13th. I believe the paperwork, though, was received on Friday the 10th.
Right,
I see
but
the chairwoman's point that,
Yeah.
the petition process is kind of open and notorious. Everybody knows when petitions are filed because we acknowledge it in a public way. And this, they
Right,
could
what,
have theoretically
was
done
my
this a month
deadline
ago.
to go to court
Right.
7 days from the date another party filed
Which you
the
don't know that happens.
nomination
Yeah, I see your
papers, or
point.
was it 7 days from the deadline for filing the nomination papers? I don't even know. So to say I should have gone to court
Right.
and I missed my opportunity, and this is a second bite at the apple, seems a little bit of an overreach there. But the other thing that I just want to bring to your attention is, one can argue a 2-year seat is a different office than a 4-year seat, but it's not. It is a special election to complete a 4-year term. And it is a seat on the same school board that cannot be occupied should it be won by the same person. We went through quite a bit of effort in the Wallingford-Swarthmore School District, a lot of conversations to make sure that this 2-year seat was on the ballot. Because there are 3 special elections in the Wallingford-Swarthmore School District this year. Every region has one. And 2 of those 3 regions have all 3 members of the school board up. And that's partly because of the challenges that have been facing school board members. And it's partly because of the fact that there was a lot of outrage on the part of people in the district as very hot and contentious conversations are being had about everything from the reassessment to whether the schools stay open. And all of this is whether masks are worn. All of this is going on, and people did not want appointed members selected by the school board making these decisions. You're now putting us in a circumstance where if the same candidate wins, we're going to have a 2-year appointment. And that is exactly what this situation was designed to prevent. It is why a candidate who could have waited another couple of weeks till their home closing to resigned 2.5 weeks earlier to make sure this 2-year seat could be on the ballot. And you're putting this region and every voter in this region, including the voter who complained, and I would ask her to introduce herself and just so you know she's real. But this is a situation that they wanted to avoid by having this election. And now you could be creating a situation. And I would just say that this is such a fluky, weird situation that I'm not surprised there isn't a statute that covers it. And I would ask you to consider that. I got to tell you, as a person who has to make decisions about resources and wearing another hat, which I do wear, which is as a member of county council, I'm not sure I would take this to court because I don't want to delay ballots going out to people. But I can guarantee you I will make damn sure every voter in Region 1 of the Wallingford-Swarthmore School District knows that there's an anti-democratic effect here if the same candidate wins both seats. Thank you.
Yes, ma'am, thank you. And, we don't have a ton of discretion, and I see what you're saying, and I understand the practical implications, but we ultimately have to follow the law. And if the law says we have to take it, then we have to take it. And I empathize with you, and I recognize that it perhaps ultimately there's a scenario where if Ms. Caruso wins both seats, that the persons go either unrepresented or represented by an appointee instead of by an elected member. But we're compelled to stay within the boundaries of our authority.
Yeah, I understand that, but I also just want to throw one other thing out there, which I meant to mention, and I apologize because I didn't think about it until I sat down. But the other issue about going to court here is people who are concerned about the effect about the special election having no effect should the same candidate win, don't really know what the rules were for going to court. I would submit to you that the party that elected to nominate the same person for both positions did have a remedy that they knew about as of August 18th, which was to go to court to get that candidate off of one ballot so they could put them on the other. That was something where they had a lot of time to do it, and they elected not to do it. You know, I don't even know under what statute I would be going to court to get this thrown out. And I'm not sure that I can. So we've just got an anti-democratic consequence of all of this. But there was an opportunity for somebody to go to court, and if the person really wanted to pick which race they were in, they could have done that, and they didn't.
I hear you. Do we have other members that wish to comment? Yes, ma'am. Yes, please come forward. And we ask you to identify yourself as you begin your presentation.
Catherine Selly. I'm actually the second vice chair of Darby Township. And just listening to what you all say, it sounds to me that that this candidate's people have upstaged a system that you people test, you follow. I mean, to me, it seems that the voters have nominated somebody to run in an election, and now a political party, Republican Party, basically wants to put somebody else in that place. And to me, that does not seem fair. And I would think that's against the law. And you say you're trying to stay within the defines of the law, but it sounds like that law is not defined. So I would ask you to keep it as it is. That's my reasoning.
Yes, ma'am. Thank you. And it's really the Republican Party has not done anything wrong. There is a vacancy and a new office created, and when there's an office that is created to be on the ballot for a special election, it is the party's right to select the candidate. So I heard what you said, and maybe it was in the way we presented things. It looked as if they were substituting one candidate for another. That's not really the case. They're nominating a candidate for the office who's already on the ballot for another office. So the issue is whether the law permits them to nominate the same person for two offices that would appear to be in conflict. It's not that they're switching somebody who was nominated at the primary.
It sounds like they are switching somebody from what the voters already selected. So that's how I see it.
I understand that, your view, and thank you. Ms. Caruso, would you like to present anything to us? Good morning and welcome.
Good morning. My name is Amy Caruso, and I live in Region 1 in Wallingford, in the Wallingford-Swarthmore School District. And my remarks will be very brief. I appreciate everyone's time today and their consideration of the issue. I am not a politician, and I am not a lawyer. And I'm looking for the best possible candidate for the seat of school director. And I believe that that is me at this point. Thank you.
Yes, ma'am. Thank you very much. Yes, ma'am.
Good morning.
Good morning.
My name is Barbara Bergerlentz. I was the one who sent the complaint to the board. Seemed like the right way to go since you guys are evaluating the nomination. It seems to me that you do have discretion. The law is not clear. There is no precedent. I don't understand why you can't be that precedent. what we are going to have is a situation where, I mean, you guys stated earlier something about 2 bites at the apple. This is what is happening there. The Republican Party is covering their bets for this candidate. They're trying to put her in 2 different slots so that she is assured to try and win at least one. This was intentional, it wasn't an accident. I am a member, I am a resident of Region 1. There are some very serious things that the board needs to talk about in the next 2 years. There are things that the school board needs to do. The fact that you guys are hanging your hats on law that clearly doesn't have clear direction for you, and that you're deferring to not make a decision is disappointing. Because I, as a voter, would like to have the chance to have real candidates in both of those slots, because I need school board members in both of those slots. There was one other point I needed to make, which of course has slipped right past my brain at this point. But
Take a moment, it's okay.
the point I'm trying to make is 2 bites at the apple is exactly what's being tried to do here. Oh yes, you would think in the entire Region 1, there wouldn't be somebody else that the Republican Party could nominate for that 2nd seat, right? Just wondering, right? Is Amy Caruso the only Republican in the entire Region 1? This was clearly intentional. It is in fact 2 bites at the apple. It's covering bets. We don't want to take bets with our elections. Thank you.
Yes, ma'am, thank you. Is there any other public comment? Yes, ma'am.
Carol Miller.
Good morning, Ms. Chairwoman.
Good morning. So just for the record, the candidates file an affidavit, and if you read the affidavit, and I'm not an attorney, but if you read it, the last sentence says that I am not a candidate for an office which I already hold, the term of which is not set to expire in the same year as a office subject to this affidavit. That to me says it's not the same office, it doesn't expire the same year. It does. And that's the candidate's affidavit that they sign. And if I recall correctly, Mary Gay Scanlon did the same thing when she ran for Congress in the 7th and the 5th, and was when there was redistricting issues, and she was on for both. So.
Well, I appreciate what you're saying, but that was different because those offices were going to change. The Supreme Court ordered the districts to change. So she ran for a special for the stub term of the 5th that was essentially going away because the 5th was moving to be a different district in the, whatever it was, the 112th Congress. She ran for the 5th and the 111th Congress, and it was for a 1-month term as the representative in the 5th. So it was kind of different.
It still was a little confusing for
It was
voters.
definitely confusing.
Anybody that didn't know the rules,
I
it would
will
be
agree with you,
confusing.
Madam Chairman. It was
So-
definitely confusing. All right. Is there any other public comment? So we'll close the we'll close the public comment, and we'll take comment from the board. I would like to say, number one, I agree that this is certainly complicated, although I think that the solicitors, Mr. Molinari and Mr. Parks, who have worked diligently on this, have sorted through it and have determined that the sections that apply to offices that are not special election and the sections that apply to non-school board would ordinarily prevent a candidate from running in this circumstance. It certainly does seem to me that the code would permit this in the sense that the code doesn't prohibit it. Secondly, we need authority to act. And to the extent there's anything unclear in the code, it's unclear that we have authority to act to take this candidate off the ballot. And I hesitate to act when we don't have clear-cut authority to act, especially when there are other remedies available. So I think I'm inclined to support Ashley's motion, but I'm interested in what my colleagues think as well.
I'm happy to speak for, I mean, so Councilwoman and Ms. Berger-Lentz, I understand your concerns, and it's really an unfortunate situation. I agree with Mr. Chairman that we have to act within the bounds of the law, and there's some concern about whether we would have the ability, it sounds like, to even, under the law, to even act differently from that. I don't intend to do that, but I do find, you know, Ms. Caruso, that a couple things really are important, I think, to all of us who promote full and fair elections for everyone, and one is trying not to create voter confusion. And I do think the Mary Gay Scanlon Congress election was very different. It was a different circumstance. I do think that this is going to create voter confusion, and I think it's also going to create a resource issue, because if you were to win both elections, it would create a need then to fill another vacancy, and we're a county that has a lot of resource issues. And so this isn't, to me, a Democrat or Republican thing. I don't mean to speak in that way. I just like to say that unfortunately, I think the law has a quirk here. You know, you could say, as a judge might, if we were judges, which we're not, I mean, they would say, well, change the law. But, you know, the councilwoman would know you're not going to get a Pennsylvania law changed for this very unique and unusual circumstance, this quirk of happenstance here. So it's disappointing to hear, but I agree with Mr. Chairman that I do think we don't have the opportunity to really properly uphold your objection.
Mr. McBlain?
Yeah, and at the risk of repeating myself, like I said, I think that, you know, the board needs to take a look at what standing we have in order to decide the issue at all. Secondarily, I believe I agree with the solicitor's analysis. And and when I open my remarks, I don't know whether it's a wise political move or not, you know, to run somebody for both of these. It certainly seems like it might create some confusion, but the law is what it is. There doesn't seem to be an exception to that. And I think one of the things that people became concerned about in 2020 and after that is when, and I'm not saying this election board, but election boards, courts changed the rules on the fly in the middle of the game. And one thing that I would like to do as a member of this board is to try to provide some certainty for the public that the rules are the rules, whether you agree with them or not, and that this board will follow them as you move forward, even if you don't like the result or you don't think it is a fair outcome or that it may cause confusion. That may very well occur. But to me, it seems pretty clear here that the result is that the board should not take any action to remove a candidate from the ballot. And beyond that, I don't even know if we have the ability to do that in this particular circumstance.
All right.
So that's my thoughts.
All right. So unless there's anything further from the board, we'll call the question. All those in favor of the motion to deny the complaint, say aye. Aye. None opposed. The motion passes. So we've done that. Next on our list is finance waiver requests. Ms. Jackson, are you going to present those today? Good morning. Welcome.
Morning. Lisa Jackson, Campaign Finance Supervisor. I currently have 2 requests for petitions to waive their campaign finance fees. We have one candidate. Her name is Alicia Mancini-Dewar, and she was unaware of the following requirements for her Cycle 3 report. She's asking that her petition be waived, or fines be waived. I also have Township of Lower Charchester Republican Finance Committee. They've had some issues with their committee. Their chairman is currently deceased and their treasurer is ill. And they are requesting that their fines also be waived.
All right. So let's get a motion.
Second.
So motion moved and seconded. So, John, I don't know if you remember from your prior involvement here, but we have had a practice for some time, and Mr. Belafonte, being merciful and thoughtful and kind, thought it would be appropriate that persons or committees, and obviously persons, the treasurers are liable for these, who have made a mistake and it's their first time, and they have good excuse, that we waive those fines. We noted at a recent meeting that there seems to be an incredible increase in people seeking to waive their fines, and not really sure of the reason why, whether it's because we have perhaps more scrutiny of the filings and we're issuing more fines, or also the general observation that 15 or 20 years ago, many township committees didn't even have their own registered fundraising committee, and kind of there was the party committees in a couple of townships, and now it seems everyone running for, judge of elections has a finance committee at this point. So there's certainly a lot more filings than there ever were. But in any event, we are where we are. We have two before us today. The motion's been made and seconded. Is there any comment? All right, we'll call the question. All those in favor say aye. Aye. Pardon me, the motion carries.
Thank you.
Next, polling place changes. Mr. Savage.
There is a second.
I do have a second
part
issue.
I'm sorry.
That's
I'm trying
okay.
to move too quickly today.
That's okay. Okay, so we also have 3 committees that that the Bureau is asking the board to approve for suspension. We have Rutledge Republican Committee, who has not filed reports since 2018. They currently have a balance of $10.93, and we cannot terminate due to them having a balance. Their treasurer resigned, and we received return mail for their chairman. So as far as we know, there's nobody manning the ship with their
So
committee.
we've made attempts to get in touch with them. We haven't been able to.
Yes.
And you're asking for us to dissolve the committee so that they don't continue to incur fines, et cetera, et cetera.
Correct.
Should they come back into operation, we can take a new committee filing and put them
That's
back in
correct.
business. Okay.
Yes.
Are there others?
Yes, there's 2 more.
Oh, yes, ma'am, go
We
ahead.
have First Republican Club of Aston Township. They have not filed since January 31st, 2018. They currently have a balance of $7,229.32, and their treasurer resigned in 2016. They have not appointed a new treasurer since then.
But they have $7,000, so I'm a little, $10, I can see
Exactly.
people forget about $10. $7,000 seems like a lot to forget about.
Since 2018. That's their last report.
And that was Aston?
No, that's First Republican Club of Aston Township.
Okay. All right.
And then we have Chester City Regular Republican Campaign. They last filed March 2nd, 2018. They had a balance of $233.23. They currently file with the state of Pennsylvania also, and they owe state fees back to 2017. Their treasurer resigned in February of 18, and then their chairperson resigned due to health issues. And they have not appointed a new treasurer or new chair.
All right. So that's it, those 3?
Yes.
This one with this First Republican of Aston with 7,200, maybe we'd table that one to the next meeting and we could try to see what's going on there, because that seems like a lot of money for people. Maybe everybody could reach out and see who we can find that could perhaps answer some questions there, and perhaps maybe the board members could reach out as well to the Aston Republicans and see what's up there. And we'll take that one up at the next meeting. So maybe we'll have a motion on the other 2. Chester City Regular Republican, and I forgot the one with the $10.
Campaign, Rutledge Republican Committee.
Rutledge Republican. Well, let's get a motion on it
Okay,
also.
so moved to dissolve the 2.
Move.
The second to terminate,
Rutledge,
Dissolve, yeah, the 2.
dissolve Rutledge and the Chester City Regular Republican.
any public comment on any of those? Okay, so we'll call the question. All those in favor say aye. Aye. Any opposed? So the motion carries. So, Ms. Jackson, I hate to just not necessarily create more work for you, because I think we're going to take on some of the work of trying to contact the First Republican Club, but we'll hold that one over just because there's a lot at issue there.
Okay,
Maybe there's something
absolutely.
going on, and we'll get it straightened out at the next meeting.
Thank you.
Yes, ma'am. Thank you very much.
Thank you.
And Mr. Chairman, the next item, we're not going to need to take action today because Mr. Savage has informed me that there's additional review that needs to be done of the proposed polling place changes in terms of physical accessibility under the Americans with Disabilities Act. So there's no need to take on that item right now.
Very good. Anything else you want to report, Mr. Savage, while you're here?
No, sir.
All right, very good. Thank you. Is there any public comment on any matters that did not come before the board today? Any general comment? All right, so I guess we're at the next meeting date. And
If we could consider, please, meeting October the 4th, that would be after the bid openings for both the voting booths and the mailing, and we would need swift action on those items, assuming everything comes in accordingly. We also were planning to take up the death records issue that Board Member McBlain brought up, and also a campaign waiver issue that is not have to do with penalties, but something Ms. Jackson and Mr. Parks and I explored. And most recently, I talked with officials in Montco, Chesco, Berks, Bucks, and Lancaster via email. And there is an opportunity to reduce the paperwork burden for campaigns that have less than $250 that they ever collect or expend. So we'd like to have a meeting, if possible, with you on October the 4th.
okay, Monday, October 4th, I'm free all day.
I'd be good in the morning hours.
I can do that as well, thank you.
And do the same time then, 9:30?
Thank you, board members.
Very good. All right, unless anybody on the board has anything else,
No, Mr. Chairman.
we are adjourned. Thank you. Thank you, everyone.